good to start now?
Sure, please, whenever you like.
Good. Okay, so tēnā koutou katoa, and welcome everyone to this, our first virtual visitor seminar since we all went online. And I'm delighted to welcome to our faculty in this, albeit virtual fashion, Professor Andrew Geddis from the University of Otago, who's joining us today from just outside of Dunedin in the south of New Zealand. And we're particularly fortunate to have Andrew as our first virtual visitor, as he'll be talking to us about the lawfulness or otherwise of New Zealand's current lockdown and use of state of emergency powers. So we can't get more topical than that. And the matter is one of great importance, not only because it concerns the Constitution and the rule of law, but also because the legality of such substantial governmental measures, I think, has not yet been properly interrogated, at least in the mainstream. So hopefully we aren't all too distracted or too scared to think about these critical issues. As many of you will know, Andrew is one of New Zealand's preeminent public law scholars, a specialist of electoral law whose work spans the fields of constitutional law and theory, Māori and Indigenous law and rights law, and who therefore is one of the very best people to tell us about the lawfulness of what's going on across the Tasman today. So Andrew, I'll hand over the screen and the microphone to you now, and remind the rest of us to remain on mute during the presentation and until we have questions at the end. So I'll hand over to you now, Andrew.
Well, thank you very much. Tēnā koutou katoa, kia ora. Welcome from the Rohi of Ngāi Tahu, particularly the Puketoraki Marae. Welcome to your place. I'm sorry I can't be on your lands, but thank you for sharing me, allowing me to be part of this virtual connection. I suspect even after the days of COVID go, we're going to recognise that this way of meeting actually has a lot of benefits going for it. Saves a lot of carbon miles, saves a lot of airtime for us in the South Island of New Zealand. So who knows, this may be the way of the future. As Yelena said, my topic today, and I'm going to try to share my PowerPoint with you now. I hope, yep, that hopefully has come up for you all. Someone tell me if you can't see it. Well. My topic for today is a slightly, well, controversial one. New Zealand's COVID-19 response, why it may very well be unlawful and why we've not wanted to say so. New Zealand, as I'm going to talk about in a moment, has put in place some of the strongest measures to try to deal with COVID-19. Whoops, what have we done there? Our response has basically shut down most freedom of movement, most freedom of association in the country for a period of time, with the effort or the idea of essentially trying to eliminate the disease. We are fortunate to be able to do that, being an island nation and so on, but the government's response right from the start has been, in its rugby-inflected words, go hard, go early. And so what I want to talk about is how the government went about doing that, and to raise some questions, not about whether it was a wise course of action or an effective course of action, because it's hard to actually argue with the results. Our latest announcement today was that we only had 6 cases in the country, and the epidemiologists seem to think we've reached this point now where there's virtually no community transmission at all. So it appears to have worked. I'm just going to simply raise some questions about the how it was done issue. And ask whether that was appropriate. So just to remind us about the timeline, it's hard to imagine, but it was only on February the 28th that the first New Zealand case was identified. Before then, this COVID-19 issue was an overseas problem. It was only February 28th that the first person from overseas came back to New Zealand with it and was identified with having it in the country. Action around COVID-19 then sort of slowly ramped up as the government came to terms with just how major an issue this was going to be. It really hit a fever pitch, or really kicked into gear the weekend of March the 21st. The weekend of March the 21st, the Prime Minister went on national TV on a kind of, one of those sort of State of the Nation type addresses, and outlined what she called New Zealand's 4-level response to COVID-19. Now, her announcement of this was in essence a messaging action. She was letting the public know what the government proposed to do in terms of a response, and what that response would look like in relation to certain events. So effectively, it was a graduated series of responses where at each level, certain controls would be put in place on the population in order to achieve certain outcomes. And as those outcomes were achieved, we'd be able to move from one level to another. The announcement of these levels had no legal meaning. It was purely messaging. It was the government letting the population know this is what's in the future for you. March the 23rd was our first case of community transmission. So the first case where someone caught COVID-19 in New Zealand from someone else in New Zealand. At that point, the government immediately announced that we were moving to level 3 on its 4-level gradation. The movement to level 3 actually carried no legal meaning, because once again, there had actually been no legal frameworks put in place to actually force people to do the things they were told to do at level 3. It was simply an advisory. Here are the actions you should be taking now in order to respond to the fact that COVID-19 is now circulating in the community. We were told that we would be in level 3 for 2 days, and that on March the 25th at midnight, we would be moving to level 4. And level 4 is the current lockdown arrangements that we have in place, which I'll talk about in a little moment as to what they actually involve. For level 4, a set of legal steps were taken to actually give level 4 some sort of legal meaning, some sort of enforceability. And so on March the 25th, there was an epidemic notice issued under our Epidemic Preparedness Act, and a national state of civil defence emergency was declared under our Civil Defence and Emergency Management Act. I'm going to put those two actions to one side for the purpose of today's talk. They're important steps in the government's overall response. The Epidemic Preparedness Act has Henry VIII provisions in it that allow for the suspension of certain legal requirements. The Civil Defence and Emergency Management Act has certain powers in it that allow for the overall control and overall guidance of how New Zealand is responding. However, the real key legal steps that have been taken to enforce the lockdown, which is what I'm really going to focus on today, are a couple of notices that were issued under our Health Act. Now, the Health Act goes back to 1956. It's old legislation, and as I'm going to argue today, I don't think it's fit for what New Zealand has actually done. I think it's been stretched in ways that it actually was never intended to, and that's why I'm going to call into question some of the legal aspects of the lockdown. The first step that was taken was a so-called Section 71M notice, which was issued on March the 25th. That notice quickly became obvious was not suitable, just would not do what it was intended to do. And so just over a week later, a second notice was issued under the Health Act, under a different provision, Section 71F. And it's those two Health Act notices I'm really going to focus on, because they really are the crux of our lockdown provisions. So, when I talk about the rules, the level 4 rules, what do I mean? Well, here's what the government's COVID-19 information page says about level 4. This is what the government has messaged to the public about what you can and can't do at level 4. People are instructed to stay at home in what we call our bubble. Our bubble is essentially our close family members, the other people you live with under your roof. You have to stay at home other than for essential personal movement. You can only leave your home for essential personal movement. Essential personal movement, as we'll see, includes safe recreational activity in a local area. Travel is severely limited, to put it mildly. All gatherings are cancelled and all public venues are closed. All businesses are closed except for certain designated essential services, supermarkets, pharmacies, clinics, petrol stations and the like, and lifeline utilities such as gas, electric, internet and so on. All other businesses have to shut. And all our educational facilities are closed. So when we talk about level 4 lockdown, it's very strict. I mean, for the last month, my travel has been into town once a week to the supermarket, and down to the local beach for a walk. And the only personal contact I've had is with my family and short conversations with people who have to stand 2 meters away from me. And that's been my life for a month. What then underpins this level 4, these rules? Well, the first notice that was put out under section 71M of the Health Act. And it really is these Health Act notices that purport to enforce the rules that the public are being told apply. Section 71M allows a medical officer of health, now note this, these powers are exercised by public servants, public health officials, not by ministers, not by cabinet. A medical officer of health can, if there is an epidemic in place, as there is, by order published in a newspaper or on TV or radio, required to be closed all premises of any stated kind of description, and also can forbid people to congregate in outdoor places of amusement or recreation within the district. So this section was used to put out a section 71M notice under which the Chief Medical Officer of Health required to be closed all premises within all districts of New Zealand, except for those accepted in an appendix. I'll talk about that in a second, how that actually worked. Secondly, he forbade people to congregate in any outdoor place of amusement or recreation until further notice. And for the purposes of the order, congregate didn't include people who maintained physical distancing. In other words, people who stayed 2 meters apart from each other. So this was the first notice that was put out to try to give legal meaning and legal enforceability for the level 4 rules that people had been told they had to abide by. There were problems with this notice that became very quickly apparent. First of all, the first bit of the notice, 1, puts in place what I call effectively the economic lockdown. And what it did was close all premises in New Zealand, everywhere. Not just all premises of any stated kind or description, which is what section 71M actually permits. Then, having closed all premises in New Zealand, the order purports to allow places that are accepted in the appendix to remain open. That appendix then says that essential businesses are allowed to remain open. Those essential businesses are then somewhat arbitrarily added to by a different government department, the Ministry of Business, Innovation and Employment, based on what they think can operate safely, based on them updating a list kept on their website. So the medical officer of health has basically said everywhere has to shut except places that I say can stay open in the appendix, and then delegated to another government department the power to decide what can be in that appendix, which is a somewhat attenuated use of the power granted under section 71M. But that is the power that has essentially shut down our economy. Because if your business is not on that list, you cannot open it and you cannot trade. The second bit of the section 71M notice purported to enforce what I call the social lockdown. You have to stay in your house, you can't hang out with other people, you can't travel and so on. Except all that section 71M notice did was forbid congregation in outdoor places of amusement and recreation. It didn't say you can't leave your house. It just said you can't congregate with other people in these places. And what is an outdoor place of amusement or recreation wasn't defined, but it certainly can't be everywhere. Furthermore, congregation specifically didn't include being 2 meters away from another person or being within 2 meters of a person for less than 15 minutes. So under the section 71M notice, it was quite lawful for me to go out with a bottle of vodka, drive over to my friend's house and drink my vodka with that friend, despite us being told in the level 4 rules, I have to stay at home in my bubble. So The Section 71M notice clearly did not achieve what it wanted to in terms of the social lockdown. It achieved the economic lockdown, but not the social lockdown. So, just over a week after it was promulgated, the Chief Medical Officer of Health put out another notice, this time under the Section 71F of the Health Act, which allows the Medical Officer of Health to, quote, require persons, places, buildings, ships, vehicles, aircraft, animals, or things to be isolated, quarantined, or disinfected as he thinks fit. This section was then used to promulgate another notice. And when I say promulgate, this was put out on the Ministry of Health website at 5 o'clock on a Friday afternoon with no press release, no notice at all of its existence. The only way I found out about it was someone happened to come across it and tweet about it the next day, Saturday morning. However, it still purports to effectively give a legal basis for the social aspects of our lockdown, because it says, I require persons within districts of New Zealand to be isolated or quarantined. Everyone is isolated or quarantined. Doesn't matter if you've got COVID-19, doesn't matter if you're suspected of having COVID-19, you are isolated or quarantined. That means you have to remain where you're residing. You have to stay in your premises, except as permitted for essential personal movement. While outside your place of residence, you have to maintain physical distancing. That means 2 meters apart from anyone else. And if your residence is mobile, you have to keep it where it is. You can't move it. And so this essentially was stay in your home, stay in your bubble, and only leave your home as permitted for essential personal movement. Essential personal movement was then defined further in the notice in a range of ways. So people working for essential services were allowed to travel to work. If you shared custody with another person, you were allowed to move your child from place to place. If you had to go to hospital, you were allowed to travel to hospital. But you were allowed to go to places to shop for essential items, so you could go to a supermarket and so on. But the element of this exception that's caused the most problems was the exception for limited recreational purposes, because you are allowed to leave your premises for exercise or other recreation if you do it in an outdoor place that can be readily accessed from your residence. No definition as to readily accessed what that means. You do it in compliance with the social distancing rules. You don't come within 2 meters of another person. And your exercise is not allowed to involve swimming, water-based activities, surfing or boating, hunting, tramping, or other activities of a kind that expose you to danger. You just cannot do those things at all while level 4 lockdown is in place. This Section 71F notice is then the main legal framework upon which our actual lockdown is now set in terms of the social aspect of the lockdown. The economic aspect of the lockdown still relies mainly on that Section 71M notice with the problems I've talked about. The Section 71F notice has effectively instituted, in a legal sense, the social lockdown. And this becomes clear because the police have issued their guidelines for enforcing the lockdown. And what they've said is that with this Section 71F notice in place, we are able to do anything reasonably necessary, include use force, to make you comply with it. We also have the power to stop and inspect any vehicle and inquire as to why you're out and about, to make sure you are acting in accordance with this notice. And we have the power to enter, remain, and inspect premises if we have reasonable grounds that you're not complying with the notice, if you've got someone in your bubble who shouldn't be there. And these powers are then, as we'll see, backed up by offence provisions, in that if you don't comply with the Section 70 notices, that is an offence under the Health Act for which you can be arrested and prosecuted. And as we'll see, that is happening. So, The Section 71F notice then has some problems associated with it. One problem, well, just one, it's a fairly major one, is a real question as to its virus. I've made the obvious joke, it's not a virus issue. I teach second year public law. I just know at my end of year public law exam, I'm going to be told that there are virus issues throughout any problem I set. I'm just getting ready for that to happen. But we have this question as to whether the notice that has been given under Section 71F actually fits with the underlying statutory powers. Remember, Section 71F says that the medical officer of health can require persons to be isolated, quarantined, or disinfected as he sees fit. The question of statutory interpretation here is, does this power permit isolating all persons across the entire country, regardless of their health status? Or is it a power that was intended to only allow for specific individuals, places, or things that were reasonably suspected of infection to be isolated or quarantined? How wide is the underlying power? Because remember, this power has been used to essentially lock down the entire country in very, very draconian ways. Well, I think there's some statutory clues that point towards the narrower reading as being the better one, the one that, probably was intended. First of all, this is a power that can be exercised by any medical officer of health. There are medical officers of health throughout the entire country. The way our public health system works is that there are health regions. In each health region, there are medical officers of health who can deploy these powers. They're then overseen at the national level by the Director General of Health. He's the one who's exercised this power nationally. But if he can exercise it nationally, well, regional medical officers of health likewise should be able to exercise it across their entire regions. And it's these public health officials that are able to exercise these powers, not politicians. And they exercise these powers with no requirement to consult with anybody else. They don't have to talk to anyone. They don't have to get input. It's their decision on whether to do it or not, which seems like a very extreme power to give to one official. Secondly, the Section 71F power has no general notice requirement attached to it. If we go back to Section 71M, 71M says that a notice given there has to be published in a paper or broadcast over a TV. Section 71F doesn't say anything about telling anyone that the order is in place. And as I noted, the way that this so-called order was put out was simply it got put up on a website on the Ministry of Health, which seems odd. If it really does give the power to effectively lock down the entire country, you'd expect that there be a notice requirement in the same way as M has a requirement. Thirdly, there's no apparent limit to its reach. If Section 71F can be used as it has been used, that's an incredibly wide power. Whereas the power to lock down public places under Section 71M is very restricted. It's just to places of amusement and recreation. So it seems odd that you would have a much narrower lockdown power under Section 71M when you've got this much, much, much wider lockdown power under Section 71F. It just seems to make M redundant. And then, again, with a little bit of statutory interpretation, it gets a bit complex, so I'll glide over it. There's a power in Section 71H and I to prohibit isolated people from travelling outside of their district until they've been treated or cured of the disease. The Section 71F power has been used to tell all people you cannot travel except in certain circumstances that have got nothing to do with treatment or cure. So once again, a wide reading of Section 71F and the way it's been applied seems to make Section 71H and I redundant. There's powers there, but they don't ever have to be used if F really is as wide as it is being used. There are then other problems with the notice, problems to do with its proportionality. New Zealand, of course, has legislation, the New Zealand Bill of Rights Act. That legislation guarantees freedom of peaceful assembly, freedom of association, freedom of movement, and so on and so on. Our Bill of Rights Act then says those rights can only be subject to demonstrably justified limits. Now, let's accept that a global pandemic that could kill thousands of people is a demonstrably justified limit on certain rights. I think we can just agree that that exists. However, legislation still has to be read consistently with these rights if it can be so read. In other words, Section 71 can only authorize notices that limit rights in a demonstrably justified fashion. And such notices cannot be applied in a rights inconsistent fashion. And some of the things that the Section 71F notice prohibits, such as surfing, seem disproportionate. There's no evidence that surfing is actually any more dangerous an activity than all the other activities that are still allowed under the Section 71F notice. There's no evidence that surfing causes more rescues or requires more medical attention than, say, riding bicycles do, which is still allowed. So there seems to be a degree of arbitrariness as to how the Section 70 power has been used to allow certain things and prohibit other things that doesn't fit easily with the requirement that limits be demonstrably justified under the Bill of Rights Act. Okay, so what I hope I've done is give enough of a flavor as to why some of us in the public law community, myself and others, feel that the legal framework upon which the lockdown has been based is a little bit shaky. It certainly seems to require pretty stretched interpretations of legislation to allow it to take place. And I think there are real questions as to whether it actually does fit with the underlying legislative framework. What then could the consequences be? Why might it matter? Well, of course, one potential problem is that if these notices are ultra vires or are disproportionate limits on rights, they therefore become vulnerable to challenge through judicial review. Whether this happens in a proper fashion or not, I guess depends on whether anyone wants to bring the case. We did last week have a challenge of sorts brought by a couple of serving prisoners. I've just given you the clip on the PowerPoint of the media reports of their statement of claim, which doesn't fill me with a great deal of confidence that it will be successful. The claims include an allegation a business leader and the Prime Minister conspired to ruin New Zealand's economy, that the United Nations Secretary General should have been consulted before the lockdown restrictions were imposed. These do not strike me as strong grounds for achieving judicial review. My worry, though, is that when this inevitably gets knocked back, the media may report it as being the High Court has said the lockdown is legal, which I don't think follows at all from the nature of this particular judicial review challenge. A second way that the notices could come under challenge, and I think, to be honest, the far more likely way that it will take place if it does, is through a collateral challenge. We've had to date 433 people prosecuted for breaching lockdown rules. The vast majority of these have been prosecuted under the Health Act 1956, Section 72C, which makes it an offence to fail to comply with a Section 70 notice. We've got one person who's already pled guilty to that charge and has been jailed for a month because the offence provision carries up to 4 months in jail as a tariff. I think it's likely at some point someone who's charged with breaching these lockdown rules is going to try to defend their prosecution on the basis that the Section 71 notices are unlawful. That because these notices are ultra vires or a disproportionate limit on rights, they're unlawful, and if they're unlawful, any prosecution for breaching them will fail. This sort of collateral challenge has been upheld in the British House of Lords and Boddington British Transport Police. New Zealand has accepted it applies to us in our law in the SEMA and Solicitor General case. Our Supreme Court accepted that, yes, if you are prosecuted for breaching some administrative requirement, and that administrative requirement is void, is unlawful, then any subsequent prosecution will fail. There's also the case of Creaser and the Queen in our Court of Appeal, held the same thing with regards a charge of assaulting an officer carrying out a search warrant. When the search warrant was found to be invalid, the prosecution failed. In a similar way, if someone was to choose to defend a charge under Section 72C on the basis that the underlying health notices are invalid, well, some poor district court judge at the first level is going to have to essentially decide whether New Zealand's lockdown has been lawful or not, which may then get appealed up the chain. And at some point, we may get through collateral challenge a ruling from one of our higher courts as to whether all of these actions were or were not lawful. So, following on from consequences of these problems, if these notices are unlawful, then a collateral challenge would result in the 400 odd charges being withdrawn. Having said that, a lot of people are charged with a Section 72C breach alongside doing a bunch of other silly things. So they'll be caught out driving late at night, their car won't be warranted, they won't have licenses, and they're out in breach of the lockdown rules because they're not out of their premises for one of the allowable reasons. So the police kind of add a Section 72C charge to all the other things they're charged with. The other possibility, if it turns out these lockdown notices are unlawful, would be the question of damages for loss. Whether there's compensation available for businesses that have been closed under a Section 71M order is unclear. My civil law colleagues tell me they can't really see an avenue for that to happen. Public law in New Zealand, you can't get damages for a public law action. So maybe there won't be monetary remedies available for people's businesses essentially being, wiped out by the fact they've had to close for 5 weeks now. Same thing goes for any compensation for events that have been cancelled because, premises are closed or because you're not allowed to congregate with others and so on. Where there will be the potential for damages, however, is under our Bill of Rights Act. Our courts have ruled that a breach of the Bill of Rights Act can be remedied through an award of damages. If these Section 70 notices are unlawful, then arrests made under those notices will be a breach of the right to be free from unreasonable search and seizure. An unlawful arrest is an unreasonable arrest. What that means is that people who've been arrested and detained, especially people who've been imprisoned, could make claims for so-called bagent damages, Bill of Rights Act damages, as a consequence. Now, once again, from the government's perspective, that might be a somewhat annoying and irritating thing, but New Zealand courts have been incredibly reluctant to give real damages under the Bill of Rights Act. Most damages awards are sort of 5,000 to 10,000 New Zealand dollars. So it could well be that that's thought to be an acceptable cost to pay in this circumstance. All right, what I've done then is try to outline why I think there are legal issues with the Section 70 notices and why those issues could have consequences. What I want to move on to talk in the last sort of 10 minutes or so is the question about why has no one actually been discussing this in the New Zealand context? Because, as I'm about to say, there hasn't been a huge amount of public debate about any of these issues. Now, there has been discussion. I've talked about it quite a bit online with my colleagues, and myself and some of our colleagues have actually held a Zoom meeting with our Solicitor General and some Crown lawyers where we addressed some of these issues and pointed to this and said, look, we think there's an issue here. So there's been behind the scenes discussion, behind the scenes questioning as to what's been going on. but there's been minimal public commentary or questioning. Really, in my sort of research and sort of following the issue through the media, I've only really found one person who's come out and sort of clearly said that they think these problems exist. It's an academic lawyer, Graham Edgeler, on a blog site for Victoria University, wrote, I say, that it's not clear that the Section 71F power can be exercised in the way it has been. It appears to be a power gives medical officers of health the authority to quarantine or isolate particular individuals or places, not everyone or everything. And then he just sort of goes on and doesn't really develop that argument much further. So there really hasn't been widespread public commentary on the matter. And we might compare the response to this particular crisis to the public law response to previous emergencies that we've seen in New Zealand. I mean, New Zealand's been, fairly unlucky in that we've had 3 major earthquakes hit the country, 2010, 2011, 2016. Following those earthquakes, Parliament legislated responses that were, as many of us in the constitutional law world said, we thought just unconstitutional. Very wide Henry VIII powers, minimal restrictions on executive authority, et cetera, and we were vocal about that. We showing you an open letter that 27 of us put together and sent off to the newspapers around the country. We haven't done anything like that in response to COVID-19 and the questions around the regime that's been adopted to respond to it. So why the difference? Well, one difference might be that my whole thesis, or everything I've said about whether the lockdown is lawful or not, really turns on statutory interpretation. I mean, really what we have to ask is, how do we read section 71F and 71M? And that, in essence, comes down to trying to work out what are the courts ever going to say about this if and when they get to see it. Statutory interpretation at its core is a prediction about what a court will think if it ever has to look at a piece of legislation. And we, recognizing we're in the middle of this emergency, recognizing, the extreme urgency of the situation, Cicero's observation, salus populi suprema lex esto, the health of the populace is the highest law. Bracton's observation, that which is otherwise not lawful is made lawful by necessity. You can't help but wonder if that's not going to operate in the background to any judicial reading of the legislation. Now, of course, it shouldn't really, because as we know from Entick and Carrington and on forwards, necessity is not the basis for founding a legal power. It's either in the law or it isn't. And our courts have in the past indicated that such sort of, very executive friendly, very, this is an emergency, things must be done type reading of legislation actually wouldn't be appropriate. This is a quote I've put up from Hamden and the Canterbury Earthquake Recovery Authority, a High Court decision 2011. I'm conscious that the powers involved in the particular legislation are both wide and invasive of rights that the common law stridently seeks to protect from unlawful interference. I think it can fairly be said the wider the power, the more drastic the interference, the more careful the court will be to scrutinise the exercise of the power to ensure it conforms with strict statutory origin. Now, what's interesting in this case is it's the High Court interpreting and applying emergency legislation. They're applying the Canterbury Earthquake Recovery Act passed after the earthquake to respond to that emergency. And yet the court's saying, we're going to be really careful to make sure that any executive powers exercised here conform with what the statute says because of the breadth of the power. Now, on that reading, or that approach, I'd say a reading of section 71 and the powers therein, it's pretty hard to reconcile the notices given with the actual legislative powers contained. Other reasons why we haven't spoken out so much is the, just concern about being seen to be acting inappropriately. One question is, look, does it really matter whether these lockdown rules have a good legal basis or not? The rules are good. I mean, they've been effective. They've essentially stomped out COVID-19. And as the Prime Minister has been fond of saying, we're in a team of 5 million people. We all have to do this together. If we don't all stick together, it's not going to work. And frankly, going out and saying that these rules are of questionable legal authority and maybe they can't be enforced, are we only going to actually end up encouraging people to ignore the rules, thereby spread the disease wider, and people are going to die? You know, that's a pretty hard thing to balance as an academic, trying to work out what you ought to do when you think you see a legal problem. Another issue that arises in the particular New Zealand context, given our particular constitutional framework and particular constitutional culture, is look, even if the Health Act doesn't give these powers, and even if the Health Act notices don't allow for what's been done, these rules are going to get put in place. All that will happen is that Parliament comes back together in an emergency session, races through emergency empowering legislation to allow it to happen, and we'll still have the same rules. So even if you raise a question about the current rules and their basis in law, the rules will be there in some shape or form because the government is going to, is able to get them in place very, very quickly. We can look at the precedent to our post-earthquake responses in 2010, 2011, 2016, where legislation was whipped through Parliament in a matter of days. And also note the political framework in New Zealand, which is that all political parties support this move to level 4. There's no political dissension as to whether we've done the right thing by doing this. And so all parties will agree, if necessary, to give a firm legal foundation for the rules. There's then a third issue which has involved a little bit of self-reflection, which is that, again, New Zealand being what it is, a relatively small country, it's quite easy for us public lawyers in the academy to get to know people in government quite well. So we know the people in Crown law, not as friends, but we're friendly with them. We know the people in government quite well. The Minister of Finance was my flatmate down here at Otago for 3 years. He was one of my best friends. So I do wonder if there's a little bit of a feeling that, look, our friends, in quotation mark, are doing the best they can. And do we really want to embarrass them and call them out for how it's been done? I don't know how widespread that is. I just flag it as a possibility, as a motive. Okay, to finish. Do we still have a problem? The place we're at in New Zealand at the moment is that we will remain at the level 4 rules until midnight on Monday coming up. So we've got another, five days under these rules. The current 71 notices expire at midnight tonight. So as of midnight tonight, the original Section 70 notices disappear. What will then happen to cover the last days of level 4? At the moment, it looks like they'll simply put out another Section 70 notice. They'll just roll it over for those last days of the level 4 lockdown, which, as I say, I have issues with as a legal strategy. I'm not sure it's legal to do that. Then at midnight on Monday, after moving out of level 4, we're going to move down to level 3 for 2 weeks. Under level 3, a lot more businesses are going to be permitted to open. Businesses can open if they can trade safely. However, the social lockdown rules are going to remain virtually untouched. I won't be able to leave my house to go into the university because the university is not going to be a business that will be allowed to reopen. So the question then is, if level 3 looks a lot like level 4, and the restrictions in level 3 are pretty similar to the level 4 restrictions, what legal basis will there be for those 2 weeks? Again, it looks possible that that's going to try to be achieved through another Section 70 notice under the Health Act. The final point to note is that our Parliament meets again from Tuesday. So Parliament will be back in session from Tuesday. One of the things Parliament has got on its agenda is consideration of COVID-19 related emergency legislation. It is possible, it may well be, that our commentary on this matter will result in Parliament racing through some sort of legislative fix to try to put all of this on a firmer legal foundation. But if that is going to be the case, I've no idea what that legislation will look like. It hasn't been promulgated around anywhere. Probably the first we'd see of it would be on Tuesday, if indeed it's going to happen. Okay, that is in essence my talk, my thoughts. Thank you for listening. And I'd be interested in any commentary, questions, whatever I can do to help from here on. Thank you.
Great, thank you very much, Andrew. Now, yes, if you could switch off the screen share maybe at this point.
Easier, there we go.
Great. So for questions, I think it might be most practical if people were to maybe type in the chat so that I can see the order of people who might raise a question for Andrew. If I can take the liberty of asking Andrew the first question. And that's a very broad sort of question, and touching upon one of the final points that you said about why people, especially academics, are less ready to be critical, even constructively critical of the government's actions. And they're all reasonable points, obviously. But I do wonder whether in these circumstances, when we're relying upon information and evidence that the government and government advisors are presenting us, whether there is still space or maybe the responsibility for people who are being governed by the government to ask about the legitimacy, not the wisdom of the decision, but about the legitimacy of this information upon which the decision to go into a state of emergency, or upon which the decision to issue the Section 70 notices are based. And there's been a lot of discussion, especially overseas, invoking Carl Schmitt and his philosophy on the state of exception, and he who defines and invokes the exception holds ultimate power, as in all three forms of governmental power. So I wonder whether that concern legitimately takes a step back when we are being presented with evidence and information from the government about the extremity of this situation.
Yeah, I mean, I think, yes, there's two things. First of all, I think we need to recognize that as academics, we're people, and that we're as, susceptible to be caught up in group concerns as is everyone else. And so certainly in New Zealand for the first, I'd say 2 or 3 weeks of the lockdown, we as a public law community were very much in the feeling of, this has got to work, and we've got to make this work in order not just to avoid the health consequences, but also, I mean, we knew what damage it was going to do to people's economic livelihood and so on. And so the feeling was, if we sort of come out and do anything to undermine this, we're going to be making it all for nothing. And a lot of people have suffered a lot to try to achieve an outcome. Now, whether that is a good enough reason to set aside all the things that we tell our students are very, very important, like, concern for the rule of law, concern to make sure that government actions are exercised responsibly and proportionately, et cetera, I don't know. I think we're going to have to do some reflection on this once it's all passed. I mean, again, to personalize it, where I'm at now is I feel that enough has been done quietly within the system to try to alert the government to the issues. If the government hasn't taken action on our concerns, my feeling is because the government thinks it can just ride it out, and that in essence it can get through this emergency, because essentially it may be in 3 weeks' time we're back to a pretty normal looking life, and there's probably not much can be done between now and then to actually challenge what's happened. And so with that, I do feel that I've got to, I will speak publicly on this now in a way I just wasn't prepared to do a week or two ago. I don't know if that answers exactly what you're asking. It's more, I guess, a personal reflection on the situation we find ourselves in and how we respond to it.
Yeah, absolutely. Yes. Thank you. All right. Joshua, you have a question, and then Stephen. Go ahead, Joshua.
Thanks. Can I just try to defend Cicero's Salus Populi dictum and get your thoughts on that? So it is conceivable that a state action could be unlawful but not unconstitutional, right? So if you understand that the constitutional order is larger and more fundamental than constitutional law, that constitutional law does not exhaust the constitutional order. So the constitutional order might include a sovereign power to defend the state from existential threat. So even if I grant that what is going on in New Zealand is not, even if I grant that it is unlawful, right, there's a separate question as to whether its justification might come from an exercise of sovereign power to preserve the constitutional order from an imminent existential threat. And separately, but relatedly, if something has to be done, the question is whether do we do it in a quasi-legal fashion, which apparently, based on your argument, is what the New Zealand government is apparently doing. But if it can't be done on a legal or quasi-legal fashion, then it will be done extra-legally, right? And that is the definition of an emergency. Either the option is we have to do something, either we do it through a quasi-legal fashion. If we can't get it done that way, we do it extra-legally. Now, between the two options, I get the sense that you would actually prefer it to be done in a quasi-legal fashion than all-out extra-legal state action. So I'm just wondering whether you have your thoughts on this. I mean, this is another way to understand Cicero's Salus Populi dictum, really.
Sure. So I fully believe that the Crown Law advisors have been wanting to do this within the rules, as it were, within the existing legal framework. And having looked around, I think they've said Section 70 of the Health Act is basically all we've got that will allow us to do that. Now, we think we can read the sections in Section 70 in a way that gets us what we want to do without, so bending and breaking them that they just fail the laugh test, right? There is, some degree of interpretive question as to whether they allow or don't allow. And so therefore, I think the Crown lawyers can say, we are approaching this on a rule of law basis. We're using the powers that exist within the existing framework to respond to the emergency. We don't need to go completely outside the system and just, in essence, say, damn it, we're doing it simply because we can't stomach the thought of dead people. I guess the counter I'd give back to that is that within the New Zealand constitutional order, we do have ways that we could achieve those outcomes in a much stronger legal sense where the rule of law is being much better complied with, which would involve recalling Parliament and giving a emergency legislative basis for these powers. That would have been achievable, but it would have required two things. One, actually doing that. You'd have to actually get Parliament back together, which is going to be a pain. And secondly, it would require the government to admit that they went into the lockdown without having the proper legal controls in place to start with. And that would be politically embarrassing. So my fear is that the government has kind of started into this using one legal framework, and its reason for not wanting to depart from that is nothing to do with, it's the only way we can do it, but rather it's doing this saves us from being criticized for having made a pretty fundamental mistake about what is needed to achieve this end, and therefore we're saved from political embarrassment. And if that's the case, well, I don't think that's a particularly good reason for carrying on in a way that has, at least questionable rule of law credentials.
Thanks, that's very helpful.
Good. And Stephen, I think you had a question. You were next on the list.
Thanks, Andrew, for that. That was really interesting. Mine's just a question for information. Has the government been doing anything else in response to the COVID-19 crisis? I ask particularly because in Australia, the Australian government passed a sort of welter of legislation recently, including some quite interesting provisions. I'm a corporate lawyer, so that's my focus, but one of the provisions they introduced there was to give the Treasurer the power to, by legislative instrument, just exempt people from provisions in the Act or to modify the operation of the Act. So essentially gave the Minister very broad legislative power. Now, it's got a sunset requirement on it. It'd be interesting to see, though, how that that operates. I just wonder whether the New Zealand government's done anything similar.
It did a little bit. So just before Parliament rose, before we moved into level 4, there was a small tranche of emergency legislation passed through, partly to allow for spending. So they authorised $50-odd billion of spending in the next little period. There were some legislative tweaks to some immediate bits of legislation, but there wasn't a general empowerment in the way you mentioned. What we do have riding alongside the Health Act provisions is our Epidemic Preparedness Act. And it's a kind of bespoke piece of legislation that has Henry VIII powers in it that allow for the suspension of legal statutory obligations that can't be accomplished under the emergency situation. So that Emergency Epidemic Preparedness Act has been used, and the Henry VIII powers in it has been used in a number of different ways. To go through them all would take too long. There's other things that have become a problem in New Zealand. For instance, the Solicitor General wrote to Crown prosecutors and told them to, in effect, ignore the Bail Act whenever they were looking at bail for prisoners who may have COVID-19, which raises questions. So I've really focused on just a very narrow range of things that New Zealand has done, because I guess they're the highest profile ones. They've certainly had the biggest impact on the population. And in that sense, I think they're probably the most interesting generally.
Thank you. And so I think we'll take the two final questions from Desmond and Amelia, I think, because we're already on tour 1. And I've already got a couple of people thanking you, Andrew, and having to attend other meetings. So Desmond, you go right ahead.
Okay, thanks. So I just, Andrew, thank you for that. It was really interesting. And I've got a specific thought and then a more general kind of idea about what's going on here. And so the more specific thought seems to me like some historical context would be useful to understanding the meaning of some of those words that you're trying to pass, specifically the word quarantine. There are a lot of the people in Australia who've done some good work on the legal history of quarantine in Australia, Alison Bashford in particular. And just to make one point about that, the difference between isolation and quarantine is in fact exactly between people who are infected and people who are not infected. So quarantine as a word and as an idea, going way back to its use in the plague and so on, has been about cauterizing whole areas and places rather than particular infected people. So it does imply that kind of broadness that I think the word isolation doesn't. And I think there are various ways in which an historical kind of context might be helpful here in working through the interpretative meaning of some of those words that you've been thinking about. And I think that the more general idea I have is that really the fundamental issue here is between different kind of normative paradigms. Like I think all professional discourses have underlying paradigms that are really the bottom line for how they understand the world. So the public health paradigm is fundamentally save lives. That's the only thing that really matters, and everything else is sacrificed to that idea. Economics says maximize utility, and if lives get lost because we're maximizing utility, that's fine. That's Bentham, right? And law similarly has a bottom line, and the bottom line is constrained power. And everything kind of sacrifices itself to this fundamental idea. So the problem is what happens when two normative discourses are clashing. And I think that's exactly what we've seen here, that the public health norm, which is save lives regardless, and the legal norm, which is constrain power regardless, are coming into a fundamental conflict. And I don't think we've really worked out how to deal with that conflict. And it seems to me a real conflict in how we're going to deal with something like that. Does the norm of save lives regardless really and truly always apply? Can it be nuanced? Can it be compromised? If so, how and on what basis?
You're 100% right. The one thing I'd add to it is that we also deal in certainly in New Zealand, we're in a situation where I would say in excess of 90% of the population would agree with the public health normative viewpoint, and a small group may accept that the public law viewpoint has some merit, but it's certainly a much harder sell than is the public health one. But I agree. I think both of your points are very well made. So thank you very much.
Right. And Amelia, I think you're the last person on the list.
You'd like me to chime in? All right. Thanks, Andrew, for a really interesting and provocative presentation. My question is much more prosaic, a public law question. So here in Australia, and you know, I've been thinking about this too from the Australian end. Here in Australia, our High Court says that both the Commonwealth's executive power and its legislative power over quarantine essentially wax and wane in response to the degree of threat, and the court has routinely deferred to expert opinion on those things. And it will utilise a proportionality test in both contexts when it's reviewing coercive measures. And my sense is that what's happened in Australia so far seems fairly defensible on the established tests. So my question is, what's the status of proportionality as a touchstone in the types of legal actions that you foreshadowed in New Zealand? And do you see any out for the government or any comfort for the government there?
Yeah. So proportionality is baked into our rights analysis. So any challenge that would be brought to the government's actions on a Bill of Rights Act basis inevitably involve weighing the proportionality of the government's actions against the importance of the right. More general judicial review frameworks, proportionality is the great unsolved mystery of New Zealand administrative law. We have no clarity whatsoever on its role, no clarity whatsoever if it should even be discussed. Yeah, there is no answer I can give you as a general administrative law answer because it might be interesting to see whether this is the scenario that actually causes the courts to come across that, because you can't think of a better one, right? To actually be weighing up, you know, how hard are you meant to be looking at government actions in these contexts? So yeah, once again, this is an area where Australia and New Zealand administrative law markedly differ. And so, yeah, I can't say whether the Australian model would be followed in New Zealand. I can't even say whether proportionality would be allowed or would be used in that analysis.
Yeah, good. I'm sure you wouldn't follow the Australian model, but maybe someone else's proportionality.
Well,
model.
yeah, exactly. Yeah. There are other places apparently. Yeah, I agree. Yeah.
Great, thank you. And there are a couple of comments from Des and Moeen who are sort of commenting on, yes, the origins of state of emergency powers, I think, if I've got it right, and how they've crystallized into our maybe normative foundations of our constitutional law. I think those are quite good points. The only thing I would add, I think, if I have the last couple of moments, is that yes, you're quite right, Des. I think that there's a conflict of normative underpinnings of our society, and it's very interesting, and that's been my perception as well, that in New Zealand, the vast majority of people of the society have accepted the public health imperative and that norm. And I wonder whether that's all the more reason for lawyers or those concerned with liberties or rights, not just the constraint of power, but the normative force of the law to try and implement a morality of how power is exercised, whether that's all the more reason to raise questions about it. Maybe not, and that I think that depends on each society. I don't think you can apply the same reasoning, say in America to a place like New Zealand, but I think those are some interesting points in my point of view. Andrew, do you have anything to add to wrap up the discussion, the conversation? We've gone over 2 o'clock. Wondering, yeah.
No, I'm conscious of that. And so I'll just thank everyone for their attendance. It was fun. It's been lovely to see you all. I hope one day we can do this kanohi to kanohi, face to face, and it'll be lovely. But thank you very much for the opportunity.
Great, thank you. And thank you to everyone else, and Grant as well for being there and recording and making sure everything goes well on the technical front. Great.
Yep. Okay.
Andrew, thank you so much.
Yeah, no worries.
Thank you so much, Andrew.
Yeah.
Yeah,
thanks, Andrew. Thanks a lot.
Bye.
Bye.
Bye. Bye.